be heard. God save the Commonwealth of Massachusetts. Court is now open. You may be seated.
Good morning, Ms. Mann.
SJC-10262, Commonwealth versus Means.
Good morning, Ms. Reardon.
Good morning. May it please the Court. Deborah Reardon representing Mark Means. The issue in this case is if and under what circumstances the Sixth Amendment right to the assistance of counsel can be forfeited. Massachusetts has not adopted the forfeiture doctrine.
Well, what do you say the judge should have done when confronted with a defendant who says, I'm going to kill my lawyer and his family? And he goes into great detail with an affidavit and all of that about his feelings, how he has anger management problems. What should the judge do?
Well, in the case of Mr. Means, the judge had the opportunity to warn him that if he had any misconduct in the future, that he would have counsel terminated. One underlying issue in this case is Mr. Means' mental health issues. And I don't believe the judge...
But he was found competent to stand trial, wasn't he?
He was found competent to stand trial. I would suggest that's a different standard than competence to represent oneself at trial. And Judge Giles was aware...
Well, it also may be a different issue than whether, I mean, I take it there's some evidence that he's bipolar. I mean, in other words, acting out isn't necessarily the same thing as competence to stand trial.
That's correct. Someone could have mental health issues, yet be unable to represent themselves at trial.
Is there anything in the record as to when, I mean, obviously at the time of this hearing, which was in August?
August, yes.
And the letter was written in March,
Correct.
right? Is there anything in the record as to when he began taking the Seroquel and what was the other?
Lithium. The record does not indicate when he started taking those medications.
Does it indicate whether he was on medication at the time that he wrote the letter?
In his affidavit in support of the motion in March that was written the day after the letter, he said at that time that he had anger management issues and he had not been treated. So that is the only indication in the record.
So one might infer that he wasn't on medication, perhaps.
Correct. Although on the day of trial, he represented he was.
I'm just saying when he wrote the letter.
Correct.
Did all this occur on the day of trial, or
No,
this was previous to that?
5 months before, wasn't it?
The letter was written 5 months before, but this was
Okay.
the defendant's fourth motion to have counsel, new counsel appointed.
He was represented by one counsel, correct?
At all times, his role...
No, my point is a different one, Ms. Reardon.
Yeah.
In many of these cases, there have been 1, 2, 3, 4, 5, 6 counsel appointed. He was represented by only one attorney, correct?
Correct.
And the attorney, as I understand it, had accepted his apology and is willing to represent him?
Yes, he had.
Well, the attorney,
Not
not willing to represent him, but
he had accepted his
apology.
apology at that time.
Now,
And
part of the facts is that in a prior case, he had done the same thing. Am I right about that? That he had threatened another attorney and been able to have new counsel appointed after his threat?
He did have a history with this particular attorney and had him asked to have him removed before.
No, I'm not talking about the same attorney as in this. Wasn't there another case where he had done the same thing?
I believe there was, yes. But then again, that goes to his issue of his mental health issues. I would suggest that there's no concrete date where you can say this is when his mental health issues began.
Well, you know,
So he could have been mentally ill at the time that he did that to another attorney.
Let's say we agree with you. And so we come out with a ruling in your client's favor. Would that give control of cases to defendants so that they just have to threaten their lawyer and they can stop the process, get a new lawyer appointed, then threaten that lawyer, stall the case, get another lawyer appointed?
No,
Wouldn't that be the result?
I don't think it would be the result. In the jurisdictions that have applied the forfeiture doctrine, there has been a warning to the defendant. If you don't stop this threat or this behavior or this pattern of behavior, you will lose your right to assistance of counsel.
I see.
But there was no warning in McLeod, United States versus McLeod,
Well,
11th Circuit case.
in McLeod, he actually physically assaulted his attorney.
I didn't think so. I thought it was a threats case. right?
I stand corrected. On McLeod, it was a repeated pattern of abusive behavior, threatening. He tried to get his counsel to behave unethically. But the court was concerned in that case that he was not given a warning. Even though they applied the forfeiture doctrine, they did express concern that he was not given a warning.
So you
In
see it-
McLeod, he'd had 5 different attorneys appointed to represent him, correct?
He had quite a history with attorneys, yes.
And am I correct that McLeod was not representation at trial? It was representation for a new trial after.
I believe you're correct, yes.
the, forgotten what I was going to say. Go ahead.
What is the principle here that a defendant essentially can force a judge to give him one new attorney? You get one free attorney, and the judge is supposed to say, "Mr. Means, this is terrible behavior. I warn you, if you do it again, you're on your own. You'll be pro se, but I'll give you one new attorney." Is that basically the rule which you're asking us to adopt?
No, I'm not asking you to adopt that. What I think each case has to be looked at individually as to what the behavior was in the case, how close to trial the defendant asked for a new attorney, and you have to consider if there are mental health issues involved, and whether this has been going on for some time. In Mr. Means' case, it was one isolated issue, one isolated incident.
And one attorney.
And one attorney, and he had all along asked for a different attorney. He was never given the option to have a different attorney.
Yes, but are we to let the defendants decide what attorney they have and they want when in a court-appointed system of appointed counsel?
Well, certainly they cannot choose their court-appointed attorney, no.
The judge stated that perhaps she could have had a more extended colloquy with the attorney in this case in regard to his preparation in this case, but she did state that he was a conscientious, hard-working attorney.
Well, that was the judge's opinion of the attorney. I would suggest that she did need to have more of an interview with the attorney to find out what exactly the issues were. The defendant said that he failed to file motions on his behalf, that he couldn't get in touch with his attorney by phone.
Had motions been filed in this case by the counsel?
There had been motions filed. The defendant had filed motions as
No,
well.
had counsel filed motions?
Yes, he had filed motions, but not to the satisfaction of the defendant. Whether the attorney gave adequate representation, though, is a question that should come out during a dialogue, during an investigation, and that was not done in this case.
Isn't
Can
your...
I go back, though? The history on this case is not fully reflected, I don't think, in the record here. The first motion to dismiss the attorney because of this breakdown and disagreement with respect to strategy was heard in October of 2004. And I don't understand this because it's not fully in the record, and that's okay. But counsel was allowed, and then counsel filed a motion to withdraw. Counsel was allowed to withdraw, but he was ordered to stay on as standby counsel.
Correct.
So what's the story there? I mean, did the defendant want another counsel appointed, and the judge said no, and I'm going to let your attorney withdraw, but he is to stay on as standby counsel? Or did the defendant want to represent himself, and the judge said, well, I'm going to allow your attorney to withdraw, but I'm going to require that he stay on it by standby counsel? I don't understand what happened in that first motion.
The defendant at no point wanted to represent himself. It was, and definitely not at that time. It was only after his hand was forced in August of 2005 when the judge said that you're going to have to represent yourself that he began to, but he never wanted to represent
So I
himself.
take it on October 8th of 2004, he was basically told you will be representing yourself, long before any misconduct. And this counsel, I'm going to let him withdraw, but he's going to be standby counsel.
Correct.
Did the defendant agree to that?
It was not what he wanted, but at that point, he felt he had no other choice.
Wasn't there there's some reference in here that at some point between October and August, this particular attorney became full counsel again, isn't that right?
Right.
That's correct. That was in February, I believe,
05.
of 2005.
By
And
agreement with the client, I take it.
Well, in
Yes.
December, didn't he file a motion of 2004, didn't he file a motion to withdraw standby counsel from the defendant and appoint new trial counsel?
He did. He filed 2 motions in December of 2004. The first one was on the 6th. The second one was on the 20th.
We don't know what happened at the hearing, but we do know that within a very short period of time, he was saying, I want new counsel.
They went into court in February to hear his motions, and
No, I understand that. I'm just trying to fill in.
but
what-
he wanted new counsel for those motions as well. He was not asking to represent himself.
Isn't your point that you would draw a distinction between loss of counsel by forfeiture and waiver by conduct, and the difference would be this warning? Is that right?
Waiver by conduct, in waiver by conduct cases, you have, the defendant is entitled to have a warning given, a warning that if you don't stop your behavior, you will lose counsel.
But I mean, that's the one distinction, because we're talking about behavior here.
Yes, we are
And
talking about behavior.
So it's really the fact that in doing what the judge did here, she never, well, at least one problem you assert is that she never told the defendant explicitly, if you keep up these shenanigans, that's the end. You're not going to get any counsel. So shape up.
Correct. And
So putting it another way, then you would assert that a client can threaten to do harm to their lawyer and the lawyer's family without running any risk of being sanctioned by loss of the right to counsel, unless there's a warning first.
I would suggest that in this case, the threat that was made was not taken seriously by trial counsel. He never reported it to the court. He, in fact, on the motion day in August, he advised his client at that point, because until the end of the hearing, he was still representing.
So let me
Mr.
just
Means.
ask you, if a lawyer took the threat seriously, does that make it different?
Well, I think that would, in this case, it would paint a different picture. If the attorney went to the court and said, I need to withdraw because he threatened me, and, and then
my
brought it to the
family.
court's attention. There was a long history between these two people. They knew each other well, and trial counsel never brought it to the court's attention and advised his client not to mention it to the court and not to adopt the letter that Judge Giles asked him point blank, did you write this letter in March? And he advised him, do not adopt that letter. So he had every opportunity, but trial counsel had every opportunity between March and August to bring it to the attention of the court and ask to withdraw.
So your suggestion is what should have happened is the judge said, I'm going to allow counsel to get off this case. Clearly, that would be a real problem if counsel remained on the case. I'm going to allow counsel to get off. I'm going to appoint you a new lawyer, but don't threaten this one. That's what he should have done?
Yes, I think she
Don't
should.
threaten to kill this one. Whatever you do, don't do that.
Don't misbehave, if you will.
But isn't the other distinguishing factor here, I take it, you would say, is the mental health issue? I mean, which has been a persistent theme which would distinguish this case from saying in every case you get one free ride. I mean, doesn't that intertwine itself into your point?
Well, I think it's very important in this case because the judge should have given him more consideration and should have looked at this letter in light of his mental health issues and not taken such a drastic measure in forfeiting his counsel. But as I say, I think each case has to be looked at individually. There are cases where they, in other jurisdictions, where they did not apply forfeiture, they applied the waiver by conduct concept, and the facts were much more egregious than this case. I would suggest this case doesn't rise to the level that requires forfeiture. Given the one isolated incident, the 5-month time span between the letter and the hearing, and the fact that the defendant behaved perfectly in the meantime.
The 5-month time span was in part caused by the defendant's conduct. He wouldn't leave the jail one time, so they couldn't get him to the court. Other time he was on a hunger strike. So the 5 months, this would have happened a lot quicker in time.
Yes, I would suggest that that speaks to his mental health issues as well.
Well, it speaks to something.
And Judge Giles was aware of his mental health issues at all times.
Was the judge aware of that other case in which he had also threatened to do harm to the lawyer in order to get new counsel appointed?
I do not believe the record reflects that. I do not know if she did.
She certainly didn't rely on that in her decision.
I'm sorry?
She did not rely on
That's
that
correct.
in her reason for forfeiture.
That's correct. She relied on that one. I see my time is up.
Can I ask one more question?
Certainly.
Just in terms of the posture, the crime he's alleged with committing occurred while he was incarcerated,
Correct.
serving a sentence. So is he still incarcerated on that underlying offense, or
No, he's not.
he's now incarcerated on these offenses?
Correct.
Okay.
I would just ask the court to, for judicial economy, to consider the issue of identity and the habitual offender portion of the trial. Thank you. If there's no further questions,
Thank you, Ms. Reardon.
I'll rest on my brief.
Good morning, Ms. Anderson-Kishore.
Good morning, Your Honors. Audrey Anderson-Kachor for the Commonwealth. Who controls the proceedings of the court, the defendant or the judge? The Sixth Amendment guarantees the right to effective representation of counsel, but it does not guarantee the defendant counsel of their choice.
Can I just ask you a couple of factual questions
Yes,
first?
Chief Justice.
And I'm looking now to the decision of the appeals court. There's nothing in the record to support the statement in the appeals court that I could find that Judge Giles either relied on or pointed to the fact that the defendant was using, and I quote, an obvious ploy to manipulate or obstruct the orderly procedure of the court and to interfere with the fair administration of justice.
I believe that Judge Giles, the defendant had been before Judge Giles for, I believe, 3 hearings.
No, I understand. I'm just saying she didn't point to that or rely on that or say, this is what I conclude, correct? Judge Giles.
Correct. She didn't come out and make that statement.
Well, she didn't refer to it in any respect, correct?
Correct.
Okay. Could I ask you another question? What we have here, as I understand it, leaving aside the issues of mental health, is a lawyer who has been represented by one attorney, who is a judge forfeits his right to counsel at trial. In other words, it's trial counsel. Is there any other case that you have been able to find that has those particular facts? In other words, where you've had one counsel, you've had one threat, and there's been forfeiture at trial?
No, Your Honor, I have not been able to find that case.
Would you agree with me that the appeals court, in saying that the decisions of courts and other jurisdictions are in accord with the forfeiture of the right to counsel we find here, and that the cases on which the appeals court relies, in fact, are quite different from the circumstances here?
The cases are different. They have a combination of some things, and some things they don't. There's no one case that I found that was exactly on point.
Would you agree with me that there might be a difference, and I don't know, as a forfeiture of trial counsel as opposed to forfeiture of counsel at a sentencing after he has been represented by counsel at trial, or forfeiture on a motion for a new trial after he has been ably represented at trial? Do you think that there's any distinction between those two aspects? In other words, should we scrutinize more carefully when we ask defendants to proceed to trial without counsel, as opposed to where they are represented by competent counsel at trial, are found guilty, and then in post-trial motions where there is evidence of quite serious conflict that forfeiture arises?
I'm not sure if I really understand the question, Your Honor. I'm sorry.
I apologize.
No,
I may not.
I believe that that defendants should be represented by counsel at most of the stages.
No, of course, and we've said that. So what I'm really saying is that when a judge is looking to conclude that counsel should be forfeited, should it make a difference, if any, even though we have said you have a right to counsel through the appellate procedure, if somebody is being asked to proceed at trial without counsel, as opposed to in post-trial proceedings? And I take it your answer is no, it's the same.
It would probably be the same, Your Honor.
Okay.
It would probably be the same.
That's a perfectly reasonable position to take, because we have said you have a right to counsel, and so, for example, a sentencing hearing is important, an appeal, and a motion for a new trial. But it struck me as interesting that I think, with the exception of one case, that all of the forfeiture cases on which the appeals court relied were all post-trial cases where there was no suggestion that there was any incompetence of trial counsel. Trial counsel, in fact, had been effective.
By threatening not only a member of the bar with death, but also his family, the defendant was attempting to force his will upon the court and to have the court give in to his desire for another attorney.
What about your sister's argument that, at a minimum, he should have been given a warning first?
The so-called cat was already out of the bag, Your Honor. He'd already threatened to kill counsel, to kill his counsel's family, sent a letter with blood in it, on it to counsel. It would have been, how could the judge say, okay, do not threaten to kill counsel again, do not threaten to kill counsel's children. If you do this behavior again.
Isn't that what the cases have, in fact, held?
Some of the cases have held that, but I really do not think that those cases were correct.
I'm sorry, just
Well, the fact that that happened in March, and we're now talking about the judge and the defendant in a hearing in August, 5 months later, and the fact that there are explicit, whether it turns out to be the case or not, but certainly the issue of mental health is raised all over. Doesn't that make a difference in terms of whether, in response to Justice Ireland's questions, that maybe something else, rather than just sort of taking that letter as that remains the status quo, even though there's, time has passed, the attorney never brought it to anybody's attention, and we've got these mental health issues? I mean, doesn't that make a difference here?
A forensic psychologist examined the defendant, and at trial, he determined that the defendant was competent.
But that's not the question, whether you're competent. I mean, it's not competent to stand trial. It's whether you're acting out in a way that, by the time that Dr. Kiley saw him, he was on pretty heavy medications. I mean, it's not entirely just a competent to stand trial question. Can he represent himself? But is his motivation in August the same? Are the same factors still playing that were playing in March, or do you have to take into account what's happened, and perhaps give a warning that behavior was totally unacceptable? We're in a different place now. You cannot do this again, or you're going to lose it.
Well, we don't know what the defendant was taking in March. We don't know what type of medication. He told the psychologist that he was taking 2 medications. That's the only...
You're talking about at trial?
At trial.
I suppose I have a couple of questions. I take it from the judge's order that the defendant, in fact, at trial, was perfectly calm and made no threats and acted in, I think she called it, a responsible manner. Am I correct?
He was very calm.
I take it that in making a determination as to competency, that the physician would want to know whether or not somebody is on very powerful psychotropic drugs correct?
I assume, Your Honor, that he would. I'm not a doctor. I know that he did testify that that this defendant said that he was taking certain milligrams of 2 drugs. He never said that I have prescribed or I
No,
see
no, no,
you
he
have
wasn't,
prescribed.
he wasn't a treating physician. He would never have done that. But we don't know. Let's assume that the defendant was, and let's assume that he was not taking, and we know that, I mean, we can almost take judicial notice of the fact that bipolar disease can be controlled by very powerful psychotropic drugs, including the ones in which he was on at the time, because the Commonwealth hasn't claimed that he wasn't on them, correct, at trial. Let's assume that he was not being treated at the time that he made that he wrote the threatening letter. Would that make a difference?
Your Honor, I'm really not familiar with if the defendant was bipolar. The psychologist never said that the defendant was bipolar.
But there's been no claim that he wasn't receiving these drugs, was he?
There was no claim that there...
By the Commonwealth?
No, there was no claim.
I mean, nobody's questioned that he was taking these drugs, correct?
In August.
At the time of trial?
No, no one questioned that. And at the appeals court, his mental health was not put into any type of issue at the appeals court. At trial, though, there was, the doctor looked at reports that had been made last year by another physician. The doctor had examined Mr. Means a year before also, and the doctor examined Mr. Means that day. He found Mr. Means to be calm. He found Mr. Means to be in control, and he thought that Mr. Means had no major mental illness, that Mr. Means had a personality disorder. At the motions hearings, Mr. Means was calm. Mr. Means pointed out to the judge that I'm calm, that I'm being good. At trial, he also pointed out, I'm being good, I'm calm.
The defense counsel didn't file a motion to withdraw on the basis that the defendant had threatened him, did he?
No, he did not, Your Honor.
So didn't the defendant tell the judge, look, it was the defendant said I sent this threatening letter, and he essentially said I sent this threatening letter because nobody's listening to me. I need a new lawyer. I'm not getting along with the lawyer that the court appointed for me.
I believe that at the motion hearing, it was a video conference in August, that the judge had the affidavit that the defendant had sent. And in the affidavit, it said that the defendant lined out what he had said.
In support of his request, essentially, for a new lawyer, he says, nobody's paying attention to me.
Yes, he said a lot of things in that.
What obligation does a judge have to inquire into the breakdown of the relationship of the lawyer and the client, and how far can the judge go?
Well, the judge should determine exactly what's going on.
Did the judge do that in this case?
On this record, I cannot tell if she did. Specifically, I know that she had the 3 hearings, and I know that she saw what was going on.
If the judge had done that, is there any reason to believe that our waiver of counsel procedure would not have been completely adequate to deal with the situation, as opposed to forfeiture of counsel?
In this case, Your Honor, the labels, I really don't think they make too much of a difference.
Why not? I mean, jurisprudence, then I think the federal courts in all 50 states think there's a difference. I mean,
well, maybe my saying didn't make a difference was the wrong term. I just hate to put a label where it's saying, okay, forfeiture is one thing, abandonment is another, but...
No, forfeiture and abandonment, I understand. Waiver is something different.
Okay, so you're saying that basically the defendant should have been warned?
Well, I'm wondering if the judge had inquired into the breakdown of into what was going on in this relationship, and it appears from this record that he might have, or she might have been able to determine that there was some problem between these 2 people that the defendant had essentially been broadcasting for a year by filing 4 motions to withdraw counsel, to have counsel withdraw, and there could have been a colloquy under our waiver jurisprudence that it seems to me might have been perfectly adequate to deal with the situation.
At a prior hearing, which was not part of the record, I received the transcript from counsel later, from defense counsel later. There were discussions that the judge discussed with the defendant and with counsel, their relationship.
But that's not before us, because it's
Yes.
not part of the record.
The only thing I can just say is that the judge is the person that's there on the front line. She was there for all of the 3 hearings. And
Let me follow up Justice Spina's question. It seems, at least from her findings, that what she focused on was the substance of the threatening letter, which is certainly egregious, and said that as a consequence of that, she was forfeiting. She was concluding that he'd forfeited his right to counsel, as opposed to what Justice Spina is suggesting. We have numerous cases which we see where there's a breakdown of communication and a new lawyer is appointed. That's a very typical pattern. And then if there's a second breakdown of counsel, quite often that triggers a more extensive thing, saying, we just can't keep going from 2 to 3 to 4 to 5 counsels. But here, it's almost as if the defendant and his lawyer were saying there's a breakdown of communication, I need a new lawyer, and the judge is saying, you wrote a threatening letter, you forfeited your right to counsel, and the two are not meeting.
well, it seems that the defendant and counsel had a relationship where they'd go back and forth, where at one time the defendant didn't want the attorney, then the next, the defendant would file a motion, the attorney would file a motion that the attorney would again be appointed counsel for the defendant. A month later, the defendant would file 2 motions the same month to have the counsel remove the standby counsel.
It's not an unusual pattern.
It just seems that there was this back and forth relationship between the two. But the defendant was basically trying to manipulate the court. Give me what I want, and then I'll go away. By his statements, I mean, he said, I did this so that I could get another attorney.
Your time is up.
Thank you, Your Honors.
Thank you.